Welcome to the What's Happening Birmingham video podcast.
Hello everyone, this is Jarvis S. Scott with What's Happening Birmingham. I am back today with attorney Angelin Jackson Sperling of Sperling & Moore PC. Good afternoon, attorney Sperling.
Good afternoon, Mr. Scott. Good to have you.
Great. Thank you for coming on the podcast today. We're about to talk about a very important topic, bankruptcy. Today, I know this video is probably going to be one of my videos that's probably going to be watched years from now. But we're in the year of December 2020, and we've had a pandemic, which has affected all facets of life. But the biggest part really affected was area of people's finances.
Correct.
As we're speaking today, we have a lot of people out of work. A lot of people can't find work. So when that happens, you can't pay your bills. Which leads to either one or two things. Either you pay the bills, or they don't get paid, and the third option, which is bankruptcy. So I wanted to bring Attorney Sperling on today to kind of explain this process, especially due to COVID-19, how things have changed and everything. But before we start, can you get, first time on the podcast, can you give people like a brief bio of yourself?
Okay, let's see how brief I can be with this.
Okay.
Of course, I'm Angelin Sperling. I've been practicing law since 2006. Bankruptcy is one of the aspects of areas of law that we practice here at Sperling & Moore. I am also one of the certified appellate mediators. I mediate cases that have gone up to the appellate court, and the court deemed it necessary or viable that a case be mediated to give the parties an opportunity to try to resolve the issue even after a trial. But today, as you said, we're going to talk about bankruptcy. So I'm ready to give you all the information that you need.
Okay, so what is bankruptcy?
In a simple term, it's just an opportunity to give business entities and individuals an opportunity for a fresh start. You have various chapters of bankruptcy. You've got a Chapter 7, which is available for a individual or business entity. And then you have Chapter 13s, which is only available for individuals. Chapter 7, you usually are driven by income. A person can have an income at a level that is great enough to prevent them from filing a Chapter 7. Mm-hmm. A Chapter 7 gives you the opportunity to discharge debts that are dischargeable. Some things are not dischargeable in bankruptcies. Things such as taxes and
student loans.
Well, it depends.
Okay.
Generally, student loans are not dischargeable. But there are circumstances in which you can have a portion of those student loans discharged. That's why it's important that you do have good legal counsel so you can determine which debts are actually dischargeable and which ones are not. There are other things that can be discharged that's not dischargeable in a Chapter 7, and those are like arrearage and child support or alimony. They're not dischargeable. So if you're trying to file a Chapter 7 because you're trying to get rid of the arrearage in an alimony or child support, that's not the appropriate route to take. If you have a income of a certain level, a Chapter 7 would not be sufficient for you either. Then there's the other chapter that most citizens will apply for, and that's a Chapter 13. So if you do have those arrearage, you can put some of those arrearage in a Chapter 13 and pay for them that way. If you're delinquent on your mortgage, a Chapter 7 is not going to afford you the opportunity to put those arrearage from that mortgage into that Chapter 7. There's no plan for a Chapter 7. That's one of the most significant differences between the two. One has a plan, Chapter 13, to pay back your creditors a certain portion of that which you owe them. A Chapter 7 doesn't afford you that opportunity.
Now, before I get into the different types, the biggest thing I know a lot of people fear about bankruptcy is they fear it's going to damage their credit. Can you kind of explain that for a moment, how people that fear and that, I want to call it a myth or anything like that, but what does it do to your credit when you file bankruptcy?
All the credit bureaus do maintain the record that you have filed bankruptcy, whatever the chapter is. And that information stays on your credit report, ranging from anywhere to 6 to 10 years. Now, think about what you're asking me. will it damage your credit? If you're considering bankruptcy, that means that you already have credit issues. Will filing a bankruptcy damage your credit any further? It depends. Are you trying to secure a different type of loan after filing bankruptcy? Are you trying to secure a new mortgage? Are you trying to secure an automobile? Are you trying to secure a personal loan? All of those have different criteria after you filed a bankruptcy, post-bankruptcy. So in some instances, it can be a benefit. In some instances, it can be a disadvantage.
So going into like chapter 7, how many times can you file the chapter 7? I've heard it's like you got 3 times your lifetime. What's that all about?
You could file bankruptcy as many times as you want.
Oh, wow, okay.
That does not mean you get a discharge. And the ultimate goal is to receive a discharge, whether it is a chapter 7, liquidation, bankruptcy, or whether it's a reorganization or repayment plan through a chapter 13.
Mm-hmm.
You want to discharge. To secure a discharge, it has to be 8 years in a chapter 7 from the time that you filed the first one, the previous one. And with a chapter 13, it has to be 2 years from the time that you actually was discharged from the previous one. So those are the time frames. But you can file bankruptcy as many times as you want, but you will not receive a discharge from those bankruptcies until those time frames have been satisfied.
Now, you may probably already answer my question. I apologize if I ask you this again. Will I be completely debt-free after filing bankruptcy, no matter what types of debt I have?
The answer to that is no. You said no matter what type of debt you have.
Mm-hmm.
No, that's not accurate. There are certain things that you can't discharge,
mm-hmm.
okay? And one of the things that I really will need for people to understand is if you have fines and penalties, legal fines and penalties, especially from a criminal act, or you're involved in an automobile accident and it's a DUI type of accident, those types of things are not dischargeable.
All right.
So keep in mind, if your purpose for filing bankruptcy is to get rid of the fines and the penalties from some criminal act that you've been adjudicated liable for, that's not the route you want to take. And that's why it's important to seek good legal advice prior to filing a bankruptcy.
Even somebody, I guess, like somebody's trying to sue you, you'd be like, oh, well, let me just go on and file bankruptcy so they don't have to get the money. This is separate from the criminal act.
Yes, that's separate. And when you do, and you say you're going to file bankruptcy post someone filing legal action against you, well, if they haven't filed the legal action and that legal action is not part of your bankruptcy petition, then that person can continue to sue you and possibly collect a judgment if they win.
Okay, and now this, I know you get this question a lot. Will the creditor stop calling once I file bankruptcy?
They should.
Mm-hmm.
There are federal guidelines that penalize and punish individuals, companies that do continue to harass you.
Mm-hmm.
But keep in mind that everyone doesn't follow the law, but you need to notify the creditors that you filed bankruptcy. If they have no means by which being notified that you filed, then they have not violated the law. Example, you have 50 creditors and you include 40, the other 10 has no idea that you filed and they're continually calling you. You need to have notified those additional 10s that you have filed. But yes, if they're on notice that you filed, they should no longer harass you.
This is some questions. But one thing I always love when I sit down and do interviews on my podcast, I always try to think what the viewers are thinking.
Mm-hmm.
I'm going to throw out 2 popular terms that you probably hear a lot, and I want to hear from your attorney perspective. Credit repair. What's your thoughts even on that? People say, well, I'll just do credit repair, and that fits the bankruptcy situation.
It depends.
Mm-hmm.
Sometimes bankruptcy is not the best option for an individual.
Mm-hmm.
There may be other means by which to resolve their financial issues,
mm-hmm.
and credit repair may be viable for them.
Mm-hmm.
It may be renegotiating the loan agreements. That may be a viable option for them. It may be refinancing a mortgage. That may be a more viable option for them versus filing bankruptcy. There are other ways to assist a client other than straight out filing bankruptcy. But the only way to determine that is to look at the person's total financial picture, collect the information, and then you advise them appropriately.
Which lead me, I guess, to this next term I see a lot. When you see these TV commercials like debt consolidation and debt settlement, how, even with that, people are like, I'll give you a scenario, it'll say, well, this company will take over all your debt, or, gosh, what's the other ones, like, credit. Say you go to, like, I'm not trying to say the company in particular. Say if you go to, like, a debt consolidation place, and then they say, well, we'll put all your debts and you pay one monthly bill. What are some of the things you would caution clients if they went that route sometimes?
There's a disadvantage to that process. Okay. One of the major disadvantages, you don't have the protection of the federal court, the federal laws to protect you, the consumer, from those continual phone calls from the creditors. Those creditors that are part of this reconsolidation, this debt consolidation, they're not bound to stop calling you. Okay, they're not required to stop sending you notices. Those phone calls can still continue to come. If the company that you choose to do this debt consolidation don't make those payments in a timely manner, then you're right where you started from. It does not prevent foreclosures. If you're in the middle of a foreclosure or about to be foreclosed on, there is no guarantee that your foreclosure will not go forward.
Yeah, and then like another thing I wanted to ask you too is, with this being, COVID-19, how has that affected bankruptcy and, then we're kind of just on not just the general tone, but just with this particular matter with bankruptcy?
Logistically, we are moving forward. We haven't slowed down. We haven't stopped. We are able to advise our clients. Those who insist on being in person, we do accommodate them, and we practice social distancing and the CDC guidelines in office. Those who do not want in-person consults or advice, we do those virtually. We do it virtually via Zooms, telephonic, WebEx, Skype. We have ways of accommodating clients. The court system hasn't slowed down. Okay. We still have hearings. We still have 341 hearings. We still have adversarial hearings and trials, and we're still moving forward.
So, what would you say to people that are, because we keep hearing in the news, more, evictions and mortgages, and we keep on thinking the government's going to bail us out. But what advice would you give somebody to say, well, I think I'm gonna hold out because I think, this stimulus may come, or this may come, I'll have to pay this bill, or a credit card company may. What would you advise them, as far as if they're thinking about bankruptcy? Now all this they're hearing in the news.
Most of the protection that are in place right now will end at the end of this month. Okay. And there is nothing that's in place related to COVID-19 that will prevent a credit card company from trying to collect what you owe them. There's nothing that prevent them from filing claims in the court, proceeding with the debt that you owe them, nothing. So don't think that COVID-19 will prevent your creditors from collecting. As far as eviction is concerned, there is an eviction moratorium right now in place. Unless Congress change something, that will end as well. If you have a mortgage, your mortgage is subject to the same criteria that they've always been at the end of this month.
So, walk me through the process. I call you, hire you as my attorney. What should I bring to my first consultation with you?
Now, this may sound strange, but please bring some ID.
All right. Okay.
ID. Okay. We need to be sure that we're talking to the individual who's actually going to file the bankruptcy. Okay. Don't send mama, don't send daddy, don't send auntie, uncle. You come, okay? Okay. You cannot file a bankruptcy on behalf of someone else unless you are one of their creditors and you're forcing them to file a bankruptcy. But when I say bring an ID if you're the person who's actually filing the bankruptcy. Bring proof of income. The court system and the statute does require that we verify your income and be able to submit that documentation. So those are the two main things, some ID, and please bring some proof of income. And then we walk you through the process. as always, our consult are free. It doesn't cost anything to pick the phone, call us, schedule a consult. We'll discuss all the procedures, and we'll listen to you and advise you based on the information you give us which one would be most appropriate for you.
So how long does it take from having the first consultation to, I don't want to jump ahead of myself, going before the court?
Well, again, it depends on which type of bankruptcy you're filing. Are you filing a Chapter 7? Chapter 7 is usually a few days, less than 60 days. You're at a 341 hearing, and then usually a couple of months later you get your discharge if everything is appropriately filed, if there are no assets to be sold. And a Chapter 7 is liquidation. And what a liquidation is, it's based upon your income. If you fall within a certain income level, you can qualify to file a Chapter 7. And all those assets that you have, which are not exempt, like your house and other assets which are not exempt, then the trustees take those assets and they sell them in order to pay your creditors. Okay. If there are no assets to be sold, then that part of the bankruptcy for Chapter 7 doesn't take place. So there's nothing to sell. So that makes it move faster.
Oh, okay. So
with Chapter 13 is 3 years to 5 years.
Oh, wow.
You're usually in a payment plan from anywhere to 3 to 5 years. So it's like a debt consolidation, but with the backing of the federal government and federal laws to protect creditors as well as consumers who file a Chapter 13. And you pay back a portion of that which you owe to your creditors in a period from 3 to 5 years.
Okay, and I know you see this a lot too. Do you need a bankruptcy lawyer to file bankruptcy? The pros and cons behind that.
No. It's not wise.
Okay.
It's not wise because some of the things I just mentioned. The average citizen doesn't have an idea of what lien stripping is or a cram down, those terminologies that can be a benefit to the debtor. They don't have the knowledge of how to go about justifying and proving that the student loan should be forgiven, if not in all, but in part. Those are some of the things that an attorney who practiced bankruptcy would know and would know how to benefit the debtor.
All right, and this is my favorite question. If people are watching this video and would love to hire you, what's their phone number and the contact information?
Okay, it is 205-868-3016. And you can reach us at sperlingandmore.com as well. Reach out. And our consult is free, and we will accommodate you, whether virtually, telephonically, or in person.
Any final thoughts you want to tell the viewers?
Seek good counsel if you're considering a bankruptcy. Do not assume that you can't file a Chapter 7. Do not assume that a Chapter 7 is the best for you. Seek good legal counsel before you make your final decision.
And where are you located?
We're located in Birmingham, Alabama, 1025 23rd Street South, Birmingham, Alabama, 35205. And the phone number is 205-868-3016.
Well, Attorney Sperling, thank you for coming on today. Thank you for talking about this very important topic. Like she said, at the end of this month, the honeymoon's over, everybody. Maybe. I love to be we won't hope to be wrong, but however, if things change differently, you may have to, go this route. So please check out this video. Please check out what's happening in Birmingham.com for more videos. And don't forget to subscribe to my YouTube channel. Thank you all again and have a great day. Bye-bye.
Thank you for watching the What's Happening Birmingham video podcast. Please check out our website, app, or subscribe to our YouTube channel for the latest videos today.